As you walk into a job interview or a college admissions office, there are several questions that may cross your mind. Am I dressed appropriately? Am I the right person for the place that I'm applying for? And have I brought everything that they've asked for? One question that usually doesn't cross your mind but should is, has the company or school that I am going to meet met their affirmative action quotas for this year? Title VII of the Civil Rights Act of 1964 prohibits discrimination on the basis of race, religion, color, sex, or national origin. Workplaces have become more diverse because of the introduction of Title VII. But there were still some stragglers, thus the birth of affirmative action. Affirmative action is a plan introduced in the work and college settings to remedy past discrimination or prevent it from ever happening. This is from the Legal Environment book by Beatty and Samuelson. There are three different sources of affirmative action. The first type of affirmative action programs is litigation. The courts have the power under Title VII to enforce it if it is needed. The second is voluntary. Employers have the right to introduce it in their companies if they feel that it is necessary to prevent discrimination. The third, government contracts. In 1965, President Johnson signed a bill that made it illegal for discrimination by federal contracts. 1/3 of all workers work for a company that is associated with the federal government. Thus, they must establish goals and timetables to prevent discrimination. This was also from the Legal Environment book. Affirmative action was set in place to protect those who were previously discriminated against and allow them to have preferential treatment in these situations. Through case studies and statistics, I hope to prove to you that affirmative action is no longer an effective way of controlling discrimination and should be completely eliminated. In the Johnson v. Transportation Agency of 1987 case, the transportation agency had never hired any women in the history of the company. Although Johnson scored a higher score on an aptitude test, Diane Joyce was hired in an effort to reach an affirmative action quota. The case ultimately went to the U.S. Supreme Court, and they found that Joyce could be hired, although she was not the obvious candidate for the job. And this is from the Johnson v. Transportation Agency case study. In the Gratz v. Bollinger case of 1995, Jennifer Gratz, who had scored a 25 on her ACT and had a 3.8 GPA, and Patrick Haymaker with a 3.0 GPA and a 28 ACT both applied to the University of Michigan, and they were both denied.